Mr. Bursch, I've already explained everything, so whenever you're ready, you may proceed.
Good morning, Your Honors. John Bursch on behalf of former MDHHS Director Nick Lyon. I will hope to reserve 3 minutes for rebuttal. Madam Chief Justice, and may it please the Court. This Court has never directly decided whether it is constitutional to give a judge a prosecutor's charging power or whether the judicial inquiry statute purports to do so. The answer to both questions is no. And because a judicial indictment is not only an oxymoron, but a structural error, the only proper remedy is dismissal. And I'll start with the Constitution. This Court has held time and again in cases like Gillis, Smith, Killebrew, and Genesee Prosecutor that the power to charge a defendant and what charge should be brought is an executive power that vests exclusively in the prosecutor, as Chief Justice McCormick alluded to in the last argument. The fact that the prosecution agrees with the judge's charging decision does not solve that separation of powers problem. If the legislature tried to delegate the judicial power to a prosecutor and said that the prosecutor could try a case, the constitutional problem would not be alleviated if a judge happened to agree that the prosecutor could put on a robe and try the case. The prosecution here gives you no reason to overturn that long line of cases, and the cases that they cite are in opposite. None of them involve the question presented here. And that's why this Court in Belanca in 1972, post-dating all of those decisions, said that the judicial charging power may not withstand re-examination. Well, today is the day that it deserves that re-examination, and both legally and politically, the prosecutor owns the charge, not the judge, and this Court should not politicize the judiciary by authorizing a judicial charging power. Now, the Prosecuting Attorneys Association of Michigan admits on page 3 of their amici brief that there is a separation of powers problem here, but for the conservators of the peace provision in Article 6, Section 29. But the prosecution concedes on page 29 of their supplemental brief that the conservators of the peace developed into an exclusively judicial role. And for that proposition, they cite our bypass application, page 26, which has the authority showing that a conservative of the peace acting in a judicial role lacked authority to indict by 1553. Now, why is that date significant? Because Article 3, Section 7 of our Constitution says the common law now in force shall remain in force. That is the common law as of 1963. And so we don't go back 400 plus years and import a discarded and discredited common law rule into today's Constitution. So Justice Kavanaugh, there's no need to go back and figure out what the knights in England were doing. We ask what the common law was in 1963. And at that point, for more than 400 years, a conservator of the peace acting in a judicial role could not indict. So in sum, as Chief Justice Roberts famously said, judges are umpires who call balls and strikes. They are not in the business of throwing the ball or swinging the bat because to do so changes their role. And this Court should say so.
Does the common law that we look at in 1963 include the practice in Michigan since 1917?
Well, except it's not clear precisely what was happening in 1917. I mean, there's a historical record that suggests there may have been some charging, but that the vast majority of courts were not. But the important thing is there's no evidence that that happened after 1963. And so again, our Constitution fixes the common law power of conservators of the peace as of that date. There were previous constitutions which fixed the common law as of those dates. And so if we wanted to import a conservator of the peace rule that was different than the common law in 1963, we would have had to do so expressly in the Constitution or to do it by statute, and we didn't do either of those things. Now, you don't even have to get into the thorny constitutional issues if you construe the statute the same way that we do, which is to not authorizing a charging power. And Justice Viviano, you were right to get right into the plain language, and I'm going to focus on some of the same sentences that you and my friend Mr. Kessel were focused on. When it says the judge having jurisdiction, that would be the district court judge or the circuit court judge, shall proceed with the case in like manner as upon formal and complaint, what that means is that the judicial inquiry process does not change the manner of the proceedings that follow. And we know that from the very next sentence where it says, and this is where you were focused, Justice Viviano, the judge conducting the inquiry under Section 3, so this would be the judicial officer who did the one-man judicial inquiry, shall be disqualified from acting as an examining magistrate in connection with the hearing on the complaint or indictment. In other words, there has to be a complaint or indictment. You don't get to skip past that, otherwise that language doesn't make any sense. And then it goes on to say, also disqualified from hearing any motion to dismiss or quash any complaint or indictment. So we know that the inquiry is not a motion to dismiss, it's a preliminary exam. So as you were already discussing, that definitely shows that there is a right to a preliminary exam, but it also shows that there has to be a complaint or an indictment, and that complaint or indictment does not come from the judicial inquiry itself. It comes from a prosecutor exercising their power after the fact. Now, there's additional statutory evidence of that. If you go back to the 1949 statute involving judicial inquiries, it had the power to indict expressly included in that statute, and that was repealed. When the legislature takes indictment power out of a statute, that means something. In addition, citizen grand juries expressly have the power to indict under their statute, but 767.4 only gives judicial officers the power to make findings and issue an arrest warrant. The word indictment appears 4 times, but not a single one of those is in reference to the judicial officer having the power to indict. Again, that different language has to mean something.
Mr. Bursch, I find these arguments compelling, especially that there were those few years where the 3 judge panels were authorized to issue indictments, and then that was taken away. I mean, it feels obviously significant. But the practice does confuse me. The fact that obviously judges were issuing indictments in these one-person grand juries, putting aside all the constitutional problems with that, right? Just for now, I just want to understand how to think about that. And it sounds like Mr. Kessel says that continues until today. He was, as a defense attorney, responding to, is this going on all the time? And is it just that no one's made the correct argument to this court before? I know we haven't decided this question. So. Yes,
several questions to unpack there. It was happening mostly in a limited fashion in Wayne County for quite some time. And for whatever reason, no one has ever made the challenge and brought it to this court to decide. In Genesee County, it hasn't been done in recent memory until this set of cases. But now that prosecutors find that they can go before this secret judicial officer and get an indictment without having to take the political responsibility of themselves issuing the charge, all of a sudden they found they really liked it. And there have been 70 of them that have followed this set of cases. I mean, that's an extraordinary change in practice, and that's why it's so important that this court address this question and put a stop to it. Because the practical realities of this is that it is very different than a citizen grand jury for all the reasons that you stated. When you have a citizen grand jury, it's the citizen standing between the judge, or between the government and the individual being prosecuted. And here it's the government who's standing in between both. And we can't have that, or we end up with the kind of train wreck, and I don't use those words lightly, that we have with this prosecution, where there was no order that ever gave the judicial officer indictment power. The indictment was filed out of time. As we've demonstrated, the evidence presented to that judicial officer was all one-sided. There were numerous other procedural regularities, including a lack of court rules that were even governing this process. The public accounting showed that the judicial officer was not even the investigator. It turned out that the prosecutor was doing all the work and feeding the judicial officer everything, and even communicating with the judicial officer off the record and providing documents off the record. So when Justice Bernstein talks about the risk of the public looking at this and thinking that the corners were being cut, they were not just being cut, they were being completely sawed off at every single stage of this investigation. And then at the end, the prosecutor took no political accountability for issuing the indictment because the judge took all the heat for that. And that's exactly the opposite of the way that this is supposed to work. Separation of powers ensures that the judiciary stays in the decision lane, and to a limited extent under this statute, an investigatory lane, and that the prosecutor issues the indictment.
The question, I guess, is who signs the criminal complaint, who authorizes the charges, whether it's the judge in this circumstance, or your position is it should be the prosecutor. But when the judge in this process signs the criminal complaint, the judge doesn't prosecute the case. The judge doesn't hire special counsel to pursue the case. The judge turns the case back over to the prosecutor. And if the prosecutor doesn't support the charge, presumably the prosecutor can move to dismiss the charges, no?
The prosecutor could do that, but the problem is it blurs the lines between the judicial branch's decision-making process, or even its investigatory process, and the charging power.
I get it. I mean, we have this charging question and the conservator of the peace and the issue you've already alluded to. I just wanted to make sure that I understand how this process proceeds, because unlike council, I've never seen not only the citizens grand jury, but I've never seen the one-person judge grand jury in effect. I don't think it took place.
We
Maybe,
don't do that in Macomb County?
well, maybe somebody made a request and we were smart enough to deny it and make
Yes.
the prosecutor do their job. But but the point is, after all this happens, it seems like this is the prosecutor's case. They own this case. They're pursuing this case. I mean, they even decided to pursue this case in this unusual manner. Seems like, to me, they should have lots of accountability for that, pro or con, or however you think of this case.
Well, you can see right in the application itself, and I believe it was paragraph 33 attached to Exhibit D of our bypass application, that they wanted the judicial imprimatur on this prosecution. That paragraph says the reason that we need, among other reasons, this judicial inquiry is because it gives it more credibility if a judge puts their seal of approval on it. Now, Mr. Kessel knows as a criminal defendant that it's incredibly difficult to persuade defendants who are charged with crimes already that judges are not in cahoots with prosecutors. Well, when the prosecutor is meeting in secret with the judge and the judge is issuing the indictment that the prosecutor then follows, what defendant is ever going to believe that they're getting a fair shake from the judicial branch?
But
That's
if
the kind of blurring of lines the Constitution prohibits.
But if we were to rule that the statute requires the defendant to get a preliminary examination, does that take care of, address all of your constitutional concerns?
It doesn't, because it's still a structural error, and it still allows someone in the executive branch to shift that political accountability to the bench. Let me give you one simple example, and then I hope to reserve the balance of my time. In the next Attorney General's administration, you may have an Attorney General, for whatever reason, who chooses to use this exact same process to, in secret, get a one-person judge to indict the governor for her decision to allow COVID patients to go into nursing homes. They could even seek an indictment of the Attorney General, today's Attorney General, for failing to investigate that and charge her with the same type of crimes that have been alleged here, the deaths of all those people. Now, it would be absurd for an Attorney General to pursue something like that. However, they could do that if this system is upheld. The only way that you can stop this and make sure that political accountability remains in the AG and the prosecutors is to force them to issue the indictment or complaint. And I'll reserve the balance of my time. Thank you.
May. Mr. Schindler. Mr. Kessel, I think you are going to go third this time.
Oh, that's right.
Yeah. But don't worry, you'll have plenty of time.
I bet.
Good afternoon, Your Honors, and may it please the Court. My name is Devin Schindler, and today I have the responsibility of representing Governor Rick Snyder as amici. Your Honors, I take great joy as a former constitutional law professor to say the next sentence. Today, I'm hoping to take the Court down the path first blazed by Madison, Hamilton, Montague, and our very own Justice Thomas Cooley, by recognizing that any interpretation of the judicial inquiry statute which would vest prosecutorial authority with a judge violates Michigan's strict separation of powers. There are three foundational elements to my argument today. First, I don't think there's any question, given this Court's precedent, that deciding what charges to bring, who to charge, and when to charge belongs exclusively to the executive branch. Justice Kavanaugh, I wrote down your statement, and I fully agree, and I believe the case law supports this. Inherently, and I would say explicitly, inherently, that is not the role of a judge. In essence, we are asking you to uphold your decisions in Killebrew, Genesee County Prosecutor, and several other where you made that specific ruling. Second, Your Honors, I would again submit there's very little question that giving such exclusive executive authority to a judge violates Michigan's strict separation. In making this argument, we are essentially asking the Court to uphold and not reverse its decision in Dearborn Township. And finally, I'd like to pick up, again, Justice Kavanaugh, on something you said. Whether or not the Sheriff of Nottingham had the power to act as judge, prosecutor, executioner when he chased after Robin Hood is irrelevant to the powers that Michigan judges have and the separation of powers that we observe in 2022. I would submit that any question regarding the powers of judges in 2022 must be analyzed, must be seen through the prism of 400 years of constitutional common law, the great separation of powers revolution brought to you by my favorite guys, Hamilton, Madison, etc., and even English common law. It is clear that conservatives of the peace have not had the power suggested by the prosecution for centuries. Turning to my first point, Your Honors, I scarcely need to make it. I have to be candid with the court. I feel like a garage band following the Rolling Stones after hearing my colleague's outstanding argument. And I have to say that we fully agree with Mr. Bursch on his point that the language of this statute cannot be interpreted as to give judges prosecutorial authority. But should you disagree, you have to deal with me, I guess, or at least my argument. Your Honors, I could quote a dozen cases. I'm going to quote a couple. Killebrew, the decision to prosecute under one statute rather than another, or to prosecute at all, is an exclusively executive function. Well, that's not what happened here, is it? The decision to prosecute was made by a judge. The decision to what charges to bring were made by a judge. And the decision when to issue those charges was made by a judge. I find it ironic, as I read the prosecution's brief, their tome about stare decisis, how important stare decisis is, and I completely agree with that, Your Honors. To rule in their favor in this case, you will have to essentially reverse yourself in the myriad of cases, Killebrew, Genesee County, where you ruled this is simply not a power held by the judicial branch. So for once, I agree with the prosecution.
What do we do about the Slattery case?
Slattery and Colacacides, Your Honors, addressed a small issue, the investigatory power. As you'll note in our briefs, we have pulled out of those cases the exact question presented. And both cases having to do with contempt authority, and we're not here to challenge that. The question was whether the judges had investigatory power. Now, the day may come, Your Honor, where you have a different case where you have to take that up, but that is not today. We do not challenge in this action that the judge had authority to investigate and issue a report. That's exactly what the statute says, by the way, issue a report. It's when the next step, which was not considered in Colacacides or Slattery, where the actual judge holds hands and joins the prosecution team. That was not an issue in either of those cases. And as Bellicano noted, that's an issue that has not been examined until Mr. Bursch and I stand before you today. I don't think it's surprising that both Mr. Bursch and I have spent hours being constitutional law geeks. This is exactly the kind of issue that's extraordinarily important to us. Because in my estimation, Your Honor, and what I've been telling my students for 18 years, the structural safeguards put in by separation of powers is the fulcrum upon which liberty is lifted. It is no small thing. I suppose in 2022, maybe it's not fashionable to care about these sort of things, but I care very deeply about them, as does the governor, because it's the structure that saves us. And look how that structure was abused here. Mr. Bursch made the point. If you look at paragraph 38 of their application, why did they do it this way? Because they wanted to walk into court hand in hand with the judge on their side already, with the representative of the judicial branch on their side already. That's exactly the kind of erosion between separation of powers that our Constitution cannot allow, I would submit, Your Honors. In terms of my second argument, Your Honors, separation of powers, I'd like to quote this court from Dearborn Township. I am going to paraphrase slightly. Article 3, Section 2 requires this court to uphold and jealously guard the right to keep distinct, separate one department from another. And in doing so, and this is a quote I've been waiting hours to say, they cited Justice Thomas and Cooley for the proposition that separation of powers is accepted as a necessity in all free governments. The executive is forbidden to exercise judicial power by the same implication which forbids the courts to take upon themselves his duties, citing People versus Sutherland. This has been the law in Michigan basically since the founding of the state, that the separation of powers, again, is the fulcrum upon which liberty rises. Hence, Justice Cooley's point that we must jealously guard this strict separation. I note that my friends at the prosecuting, as Mr. Bursch noted, my friends at the Prosecutors Association agree, saying, yeah, there's a separation of powers problem here. No question about it. Which brings me to what I consider to be the Hail Mary here by the government. Oh, good heavens. Sheriff Nottingham, 1200s, or Knights of the Round Table, 1,000 years ago, were allowed to be executioners, prosecutors, judges. They got it all. And therefore, you should read into the Michigan Constitution in 2022, Devin, let's live in the present. 2022, you should read in the Constitution that they have this full array of powers that knights did, et cetera, et cetera. Your Honors, well, as a matter of separation of powers, I just have to say that's crazy. Again, as Mr. Bursch points out, our Constitution gives us a snapshot in time, 1963. And I don't have to read any further than the prosecutor's brief in this matter to see that for centuries before 1963, we had already recognized as early as 1553 in the reign of Mary I, this movement towards separating the executive function of sheriffs from the judicial function of justices of the peace. And that has gone on year after year and expanded and expanded. It became one of the core principles upon which the United States Constitution was found, and I would submit the Constitution of the state of Michigan also. Your Honors, now that I've spent some time with English history, I think it's only appropriate that I end with a quote from an English author. I'm also going to steal from the Prosecuting Attorneys Association, which used the same quote. In our system, judges judge, prosecutors prosecute, and never the twain should meet. Thank you, Your Honors. I do have 43 seconds left, so I spoke faster than when I prepped. Do I have any questions you'd like to ask? Thank you for your time.
I don't see any. Thank you very much. Thank you. Now you're up, Mr. Kessel.
Hello again, Your Honors. Christopher Kessel on behalf of the people, and I think you know everybody else now. Your Honors, while appellant stands before you quoting case law, let me quote to you our state's Constitution. What our Constitution tells us is that, yes, sorry, Your Honors. What our Constitution tells us is that no person exercising powers of one branch shall exercise powers properly belonging to another branch, except as expressly provided in this Constitution. So what our Constitution tells us, Judge, is exactly, or Your Honors, what this court tells us, that for over a century, the creation and use of the one-person grand jury has been recognized and upheld as a constitutionally permissible method of prosecution in this state. There have, of course, been changes made over the years. But when our framers, literally in 1963, Your Honors, not that long ago, when they had a decision to make, whether to passively allow for the dissolution of or to expressly repeal the one-person grand jury, they instead chose to reaffirm their constitutional commitment to this process. To be clear, Your Honors, this court, too, has repeatedly upheld the use of and the constitutionality of the one-person grand jury, as we discussed earlier to Justice Bernstein's point, especially in cases where high-level government corruption does result in the victimization of, in this case, an entire city.
But Mr. Lyon's not asking us to strike the statute altogether. He's saying we have to limit what powers it gives to the judicial investigator. If the judge is just investigating, I don't hear Mr. Lyon to be complaining about that. It's when the judge also gets to make a charging decision, which is an executive branch decision, that the constitutional problems arise, right? So it's not, I don't think he's saying throughout the whole statute.
Well, Your Honors, in both Slattery to, I believe, Justice Kavanaugh's question and Kolakasitas, both of those cases recognized that defendants were indicted by the one-person grand jury. Specifically, in Kolakasitas, what this court, in discussing the facts of that case, recognized These documents were the evidentiary basis upon which appellant had been indicted by grand juror Piggins for conspiracy to bribe a police officer.
But correct me if I'm wrong, in neither of those cases was the particular challenge that is before us today raised, right? No one has before said to this court that the judge, by the plain language of the statute, doesn't issue the charges, and if the judge could, it would create constitutional problems, right? This is the first time this court has considered that particular challenge. We didn't consider those challenges in those cases.
Your Honor,
Am I right?
I would certainly concede that point, but I would respond to it by noting that the holdings in Slattery and Colacasitas were extremely broad. They were not limiting in any way. What this court said in Slattery, which echoed a long history of this court's rulings on this matter, was that, so there may be no further question, we hold that the judge conducting a one-man, and we've evolved a little bit, one-person grand jury statute is acting in a judicial capacity. And the reason for that rationale, Your Honors, is the grand jury does exist. Any grand jury exists in this kind of nebulous world where it's not part of the judicial branch. But a grand jury has always been understood as exercising judicial power. And so that is why in Mundy in 1921, in Doe, I think in 24, and then in Slattery in 45, we have this recognition that the one-person grand jury acts in a judicial capacity. And so there is no separation of powers issue, whether it's investigative.
I mean, I feel like we're doing a chicken egg thing here. I mean, it may be the judicial lane to investigate. The question is whether it's properly the judicial lane to also issue a charging decision.
And
So I don't know if I'm the chicken or you're the egg, but I feel like we're talking past each other a little bit.
Whichever, I'll be the one that's more insulting, I guess, Judge, if that's possible. Your Honors, the answer to your question is this, and I understand the argument that, well, investigating might be a judicial function, but perhaps charging isn't. But that's, I guess, the beauty, for lack of a better phrase, of this court's decision in Colacasitas, because it went even broader than Slattery. And what this court said in Colacasitas was that whether executive or judicial in nature, the exercise of such powers would not violate Article 3, Section 2, either because they are judicial in nature or because, if executive, they are expressly authorized by Article 4, Section 29, and thus within our exception stated in Article 3, Section 2. There is no question, Your Honors, that Michigan is probably unique in this one-person grand jury statutory scheme. But what Justice Frankfurter noted in his concurrence in Oliver was that there is nothing anywhere that prohibits the state of Michigan from altering the makeup of the grand jury. He literally says they could have 23 people, they could have 17 people. He literally says there could be one judge. In that case, the issue, the reason that the statute then was found to be problematic was because in Oliver we had a one-person grand jury, I think, holding someone in contempt, trying them, convicting them, doing all of that in secret. This is very much not what's happening in this case. So I suppose in a broader question, the legislature decided that this was something they were going to do. It's a different method of prosecution. But also the key that the appellant and the professor never, ever, ever respond to is that literally our Constitution allows for this one exception. And again, the beauty of Colacasitas is unlike where we talk about the preliminary exam. And this is, Justice Kavanaugh, this is kind of where we were headed down the road earlier. Unlike in the preliminary exam statute, where we don't know what the legislative intent was. We don't know. We understand what was happening and what may have been happening, and we can speculate as to why things were happening. But when it comes to this issue, we know, no question in black and white, that our framers had a conversation, that the delegates had a conversation, and it's reprinted in Colacasitas, where they say, hey, we were going to repeal this conservator of the peace language. We didn't think it was appropriate to have anymore. But we received word from a judge in Wayne County, and that judge reminded us that if we lose the conservator of the peace language, perhaps the one-person grand jury may go with it. So what the framers did is they had this conversation, and then they literally took a vote after having this conversation, and they said, we're going to keep this conservator of the peace clause. So if our entire judicial system is based on following the Constitution, regardless of if our personal feelings, maybe we don't appreciate that, or we do or we don't, What is crystal clear is that our framers decided to keep this language in our Constitution for the express purpose of allowing the one-person grand jury to remain.
But do you agree with the counsel for Mr. Lyon that the conservator of the peace hasn't had the charging power for hundreds of years? I mean, why does that help you that much?
Your Honor, I would disagree, and, I would disagree, and the Colacasitas Court would disagree as well. When they talked about the conservator of the peace, they talked about having the power to get up a case, and they talked about taking charges. I understand that that is not the terminology that we would use today, but to get up a case and to take charges. Now, eventually, yes, that splits off from conservator of the peace and then justice of the peace. But, Your Honors, it is crystal clear that this court has recognized, and our framers recognized, that the conservator of the peace language, even if the court believes that what the grand jury does, it doesn't do as a grand juror, that this conservator of the peace language is what allows the one-person grand jury to exercise what could traditionally be called executive powers. There is no response to that by appellant because there is none. If our purpose in this case or in any case is to have the Constitution tell us what is supposed to happen, then the Constitution could not be clearer that the conservator of the peace language that allows a judge in their jurisdiction to be a conservator of the peace, that is what, partially at least, and I'm not conceding in any way, Your Honors, that what the grand jury does, they do as members of the judiciary. But even if what this court believes are potentially executive powers, our Constitution expressly allows for that to take place.
Counsel, does the statute require that the judge authorize the charges as opposed to the prosecutor? And if so, can you point me to what language says that?
Your Honor, as counsel noted and as the professor noted, the word indictment appears several times in the one-person grand jury statute. Now, I understand that there is a statute that was cited by appellants where it discusses, well, there are multiple different potential definitions for the word indictment. But, Your Honor, we have a section of statutes dealing with grand juries. We have a statute that lists grand jury as what this is called. So I think it is fair to say that indictment here traditionally means what it's been understood to mean, which is an indictment by a grand jury. Now, what the language indicates when discussing the secrecy provisions, never mind the fact that complaint or indictment, so obviously an indictment comes down, what it talks about is secrecy provisions after an indictment for a felony has been found. And, Your Honors, to read everything in context, we have an inquiry, a search for something, and then we have language of indictment is found. So I think it's pretty clear that when the legislature talks about this indictment, they're talking about what happens after the grand juror concludes their inquiry and they find charges should be filed.
Later on, the statute says, upon the termination of the inquiry, if the judge shall make no presentment of crime or wrongdoing as to any person, et cetera, could that refer to the complaint instead of an indictment, a step that precedes the indictment or the information? Could it be a recommendation of charges? I'm trying to... Well, you're saying basically based on where this is located in the code and a few stray references, that's where you're gleaning. I mean, we're sort of gleaning from this statute, right? This procedure. Well, and I'm trying to understand if the language isn't clear, does it have to proceed in that fashion, or is it, is it the requisite or the required procedure, or is it just the one that people have followed?
Your Honor,
there was language that talked about the orders returning indictments shall be signed by 3 judges, and that was removed, but we don't have anything that talks about the order returning an indictment being signed by the investigating judge, right?
Well, Your Honor, and the people's position is that when the language earlier is the case shall proceed on complaint or indictment, that's what that language means. Now, Your Honor, what I would point out is that section of law also clearly indicates that charges are filed. When we talk about an arrest warrant based on charges, maybe more accurately to this court's point, the judge having jurisdiction. How can a judge possibly have jurisdiction if there is, how would we know what judge has jurisdiction if there isn't a case in a jurisdiction? Or when you talk about the judge shall proceed with the case matter or proceedings, how can there possibly be a case if there are not charges filed? And again, additionally, Your Honor, that indictment language clearly contemplates that an indictment has been found by the judicial inquiry. Now, I think if to get maybe either the beginning or the tail end of your question, Your Honor, I think the courts have made it clear that in Mundy, I believe it was, a grand juror should not be in the business of writing presentments if there are not charges that have been filed. Presentments should accompany complaints or indictments, but there shouldn't just be, grand jurors penning descriptions of what it was that happened before them if charges are not filed afterwards.
Well, this statute expressly allows for that, right? A report of no finding of criminal guilt as to any person or persons involved in the inquiry? The judge can make that?
Your Honor, let me be more specific. As it relates to a report of no finding as differentiated between a long expression of what it was that happened. If the grand juror writes there's been no finding, then that's a report of no finding. I'm more talking about a long summary of what it was that went on before the grand jury. Now, Your Honors, I see my time is running
Counsel,
short.
I just have a very quick question.
Of course.
You said in the beginning of our conversation that the defendants would clearly like to have had a preliminary hearing. However, that ultimately that you were using the tools that were available to you and that this was the course that you chose based off of the tools that were available to you. I guess the essence of kind of my question after we've had kind of a lengthy argument and discussion, and you've done an excellent job, by the way. All the attorneys here have done an outstanding job. But I just think my question should be that as I kind of look at this, from a constitutional perspective, I know we're looking at this from a statutory perspective as well as a constitutional perspective, but from a constitutional perspective, these folks did not get a preliminary hearing. And the question I'm going to really pose to you is that if the court were to uphold your argument, could this curtail the rights of ordinary, everyday citizens?
In the sense that at some point they become defendants, Your Honor?
Correct.
Or, Your Honor.
And again, we were talking about these folks are more high level, so, and you were saying that this is used, for high level people. But my question to you is that if you're going to use this for high level people, and I think this has been alluded to a little earlier, should the court be concerned, based off of your comment before, that you use the tools that you're given? And even though this is what people would prefer to have a preliminary, hearing, since their lives are in the balance as well, what is the impact if the court upholds your argument as it pertains to the everyday person and to their constitutional rights?
Madam Chief Justice, I see my
absolutely.
time. Oh, I figured, but I just,
Yeah, thanks for asking.
I want to be
Go for
polite.
it.
Justice Bernstein, so to answer your question, if the court were, let me take a step back. This is not a procedure that is just used for cases involving governmental corruption.
No, I understand.
And just to your point.
Of course.
So yes, everyday citizens could potentially be impacted. What all citizens are entitled to is a finding of probable cause. Now, the reason the one-person grand juror is different from for example, preliminary exam, is in a preliminary exam, we have, defendant sits at the table and the judge sits on the bench, and then they make a decision based on what this defendant may or may not have done based on the evidence. A one-person grand juror investigation is in some ways more organic and, I don't know what a better way to say this is, almost a more wholesome way of looking at a matter. Because what happens in a one-person grand jury is a grand jury, or any grand jury, and remember, Your Honors, these questions could potentially apply to both sets of grand juries. You have a set of facts that are presented to a grand jury.
And again, even though this isn't the citizens.
Now I'm just speaking specifically to the grand jury. Is potentially a one-person grand juror conducts his own investigation, his or her own investigation. The prosecution can be involved or not. The one-person grand jury then makes his or her own decisions completely, not just based upon the questions the prosecutor wants to ask or not. The reason a one-person grand jury is so effective is that here you have a judge who can sit and ask his or her own questions. And, Your Honor, to your point, in this case, we have a set of defendants who exist now. But, Your Honor, there were defendants who were charged in the previous investigation that were not charged by the one-person grand jury. because the one-person grand jury took a more holistic approach to investigating the facts of this case and determined that charges should not be filed against those defendants. And to this specific defendant, there were people who died, whose deaths were originally charged on this defendant. And some of those deaths have not been charged by the one-person grand jury now. So when you talk about fairness or what could potentially happen to the average person, what I think is the average person probably wouldn't think too much about this, but to the extent that they would feel comfortable understanding that a judge at the end of the day is the one making the probable cause determination, and that it is our Constitution that allows for that finding to be made. We may not, I understand that on some level, Your Honors, it may seem odd that a traditionally executive power is being exercised by a member of the judicial branch.
And not the people, the citizens.
That's correct, Your Honor, and I take issue with this whole, politicizing and dodging politics. I mean, clearly no one in this office has dodged any sort of political ramifications for this case, but it is at bottom, as they say. Our Constitution is what is supposed to guide us through complicated questions just like this. And our Constitution expressly allows for this type of procedure to take place. If it needs to be changed, then the legislature can do that, or the Constitution can be amended. But, and I know my time is up, Your Honor, but I would say respectfully that this court should recognize what our framers wanted and implemented in our Constitution and allow the one-person grand jury to stand as it has been used in this case. Thank you, Your
We'll
Honor.
see you in a few minutes.
I was going to say, I'll be back, so if you have any other questions.
3 quick points, Your Honor. First, the prosecution puts all of its chips on Cola Casades. So it's important to look and see what that court actually held. At 379 Mich at 91, it said, because, quote, conservators of the peace at common law possess the power to investigate crime for the purpose of apprehending offenders, end quote, circuit courts exercising the same power in a judicial inquiry did not violate the separation of powers. It was about investigation and apprehending. It didn't say anything about indicting. Second point, my friend says that our indictment plain language argument on the statute depends on a different understanding of what indictment means, but that's not accurate. Our point is that nowhere in the statute, unlike the 1949 statute, does this 767.4 give the power of indicting to the judge. It just doesn't. And Justice Viviano, you were right to point to that language towards the end of 767.4 because it does authorize the judicial officer to issue a report of no finding of criminal guilt. Earlier, it gives them the power to make a written finding that an officer should be removed from office. And there it specifically says the finding shall be a sufficient complaint as a basis for removal of said officer. But interestingly, nowhere in there does it say it can also, the judicial officer can also make findings that are sufficient complaint to result in an indictment. It's just not there. And finally, the last point is that at minimum, the 767.4 is at least ambiguous. I think our reading is the plainest, but if it's ambiguous, as you know, all ties go to the defendant, and that power should not be recognized. In sum, Director Lyon was a 30-year public servant. He had nothing to do with the switch in Flint's water, and at the time that the Legionnaires issue developed in Flint, he was in the process of merging Michigan's 2 largest agencies, supervising more than 10,000 employees. And when this issue came to him, he charged his top medical officers and epidemiologists to look into the matter and decide what to do and direct local public health officials, and that's exactly what they did. Justice Bernstein, an average person, would expect in this situation, as in any, that prosecutors, including the Attorney General's office, would take the public and legal responsibility for filing the complaint or the indictment and not push that off on a judge when that's not the judge's role. This court should reverse and order dismissal.
Thank you very much. The case will be submitted.